wasn't her requirement to save the video.
Two lines. I can look it up, Judge, if you'd like.
In December 2022, a 13-year-old boy named Charlie was living at Grafton School, a psychiatric residential treatment facility in Virginia where he had been placed to recover from a childhood marked by sexual and physical abuse and neglect. Instead of healing, Charlie was dragged across the dorm room floor by a staff member, his shirt wrapped around his neck. The insurance company offered $60,000. Broughton Injury Law, a veteran-owned firm out of Richmond, said no thanks. They demanded $6 million. The defense came back with $500,000 a week before trial, and then during trial actually lowered their offer. Then, on February 13th, 2026, a 7-person jury in Winchester deliberated for just 3 hours and came back with a $20 million verdict. Today, I have two of the men who tried the case, Broughton and Sharif. Gentlemen, welcome to Behind the Verdict.
Thank you, Chad. Thanks for having us.
Yes. Tell me a little bit about how did the case kind of first come into your office, and what did you kind of first learn about what happened to Charlie?
The case came in, I guess, probably 2.5 years ago. And this was back when I was the only attorney in the firm. We have 4 attorneys now, but it was myself and the paralegal at the time. So Charlie's dad contacted me, and as he has stated before, like, I was not their first choice. I was the 4th or maybe 5th law firm that he called. I spoke with Charlie's dad. He talked to him over the phone. He described what happened. He had seen the video, but he didn't have a copy of it yet because he'd seen it during like a prosecution, but didn't have a copy. But described it to me, and it was intriguing enough, and it was one of those things where it's like, if I believe half of what he's saying, then it's something worth pursuing, or it's something at least worth investigating. So, and also, to be frank, smaller firm where you're building your book. You're like, you know what, I'm going to take this on. Let's see what happens. And so sometimes it works out well. More often than not, it's like, oh, I wish I hadn't taken that case on. This ended up being one where it was like, okay, that was a good choice, but that wasn't always that clear. This involved a young boy who had a history of being abused. He was certainly not perfect when this incident happened, and he wasn't perfect after the incident happened. And it was a case where, for a long period of time, I struggled with trying to figure out, like, what is this case worth? Because it didn't really fall into normal metrics. Okay, well, we've got, this amount in medical bills, this treatment, these, permanent injuries, or this sort of loss of earning capacity, all those sort of things at trial that plaintiffs' attorneys like to look into, and justifiably so. This was a young boy who had a whole host of diagnoses before this incident. He had a whole host of diagnoses after this incident. None of them changed. We actually, I tried to get a psychiatrist I did get a psychiatrist just to get the answer that was like, I can't say to a reasonable degree of medical certainty that, he was clinically, different after this incident versus before. So it was a case where I had a hunch, not too long after I took on the case, did get the video, and the video was damning enough to where I felt strongly about it and felt like it was worth continuing to pursue. But, as you were sort of like teeing up this, the trial in this case, we weren't getting traction with the defense. And the defense kept sort of pounding to us in sort of the early discovery phase of, like, your case is not worth anything. You don't have any damages. You've got no economic damages. You've got no other damages, and so we're not valuing this case. And they didn't put an offer, that $60,000. They didn't put that on the case until 2 months before trial.
Sharif, do you want to maybe just talk us through what happened in December 2022 and what Michelle Yates did to Charlie that kind of started this?
So it was the bulk of the incident was her pushing Charlie to the ground a few times, then grabbing him by his shirt, and that which ultimately yanking it around his neck, and then dragging him across the dormitory floor to leaving him in outside the dorm in a hallway area alone for roughly 45 seconds or so. That was the incident. And the physical injuries that came from the case were really just bruising and some scrapes. From a traditional personal injury lens, right, you're not thinking, oh, wow, big damages. But what the real damages were, and we even used one of the graphics during trial, like the iceberg analogy, right? The tip of the iceberg is what you can see, but let's look at what's actually below. It was a child who was at a place that was supposed to care for him, that he trusted, he had hope, he at least had some sense of dignity. And those intangible things, and arguably the more important things, his trust in that facility, his trust in that caregiver, his hope for recovery, his hope for having a place that would support him, and then of course his dignity is what we argued was taken from him as a result of the incident. Now, before we got there, though, I mean, I think it was fair that when you showed that video, even within our office, I mean, nobody thought, "Oh, that's great," right? And I mean, people thought, I mean, it was mixed reviews. Like, of course, that should never have happened, especially to a child. But then, of course, the question is, well, how is a jury going to receive that? And I think our firm even struggled for a while just trying to understand what would this look like in front of a jury. And so we started with a focus group and one evening, and we focus grouped a handful of cases, and this was one of them. And the reaction from that focus group made it very clear that this case wasn't just a good case, but this case had significant value. And at that point, it's when Gray decided, all right, all hands on deck. We're gonna put everything we've got into this one.
Let's talk about the surveillance video, because there's some twists and turns here, right? The incident was captured on camera, and you just started talking about when you guys finally did get the footage and you saw it, and then you shared it with some focus groups. What was going through your mind?
There were two videos, or I guess there was multiple videos, but one was there was video from inside the dormitory where the incident happened, where Michelle Yates pushed Charlie to the ground, dragged him across the floor by his shirt. It became wrapped around his neck, and then kind of unceremoniously, with the help of another employee, deposited him into the hallway by himself. There were also cameras in the hallway as well. And even though we had sent, preservation letters and things of that nature, the camera footage from the hallway was taped over. It was not preserved. And so ultimately it was not available. And that became super important because, according to Charlie, what happened after he was put into the hallway by himself, I mean, Charlie had a history of self-harm. He had just been dragged across the hallway, shirt wrapped around his neck. He then tried to strangle himself with his own shirt when he was in the hallway by himself. And so you can imagine this poor young child who's just been traumatized and who has a history of self-harm and is just like thrown out there by himself, is then trying to hurt himself. And so the fact that that was erased, we don't know what the video looks like. There were people who saw it. Like, there was a deputy who testified that she saw the video and described what happened. Also, Charlie's dad had seen the video and he described what it was like. Having that evidence of where almost the idea or the thought of it or the imagination of the jury was perhaps more powerful,
right,
and more damning than if we'd had the footage itself, because we were able to talk about that footage, why, the recklessness of Grafton and it going missing, and what that probably pointed to in terms of their culpability. And it was one of those things where it's sort of screamed cover up.
Yeah.
And there was a lot of fighting to get to that point, to where, because they even, tried to say that the footage didn't even exist and all this other stuff. So there's a lot of discovery that was pointed at the video evidence or lack thereof. And so it was quite a battle.
I mean, how did you guys even discover that there was this? I mean, I guess the dad had seen it and he maybe talked about it, but how did you discover that it was magically erased and destroyed?
So during the course of discovery, we found out, yeah. But so it's one of those things where we're learning things from the client, from the dad, and anyways who's practiced personal injury law. It's like you're getting information from your client, and sometimes it's super reliable, and sometimes it's kind of like, I'm not sure how reliable this is. It ended up being very reliable information, and thankfully, I think if it had just been the dad's word that he had
Right.
seen this video and that was it, that would have been tough.
Yeah.
But there was a law enforcement officer who had seen the video, and it wasn't her requirement to save the video because it wasn't necessarily germane to the criminal prosecution. But she had seen the video, and so the dad gave us her information. We contacted her, and so we then had pointed discovery requests and responses that we received that sort of pinned them down to like, yes, there were these cameras that were in the hallway during this time, and yes, they were operational. And yes, they would have recorded anything happening on those dates. And no, they didn't have that footage anymore.
And the chief deputy, she was willing to come and, testify because she had already been involved with the criminal case. Is that how
Yes,
that
she
worked?
was,
Yeah.
and wisely, Sharif and the other people on our team decided to have her as our first witness. She was our first witness in the trial. And so having that person stand up in a uniform, she was above reproach. She had no dog in the fight. She's a law enforcement officer coming in to basically just say what she saw.
Was Grafton happy and supportive and cooperative, or how painful was it on a level from 1 to 10?
I mean, probably a 7. I don't
Okay.
know. But there were okay. And some of the written discovery, not too bad. But then on the actual depositions and things of that nature, probably a 9 or a 10. We were forced into some situations that ultimately probably made our case stronger. Like, for example, we didn't want to have to put Charlie through having to testify and being deposed and all that sort of stuff. We actually fought. We filed a motion for a protective order that he not be required to be deposed or have to testify. We lost. So they had the opportunity to depose him, and they were absolutely brutal. Charlie talked at one point about he just wanted to be a normal child. He just wanted to have a normal childhood. And defense counsel pointedly asked him, well, were you normal before this?
Oh, right.
So imagine, saying something like that, and the implication that has, saying that to a child who's endured unthinkable trauma, not only from this incident, but from his, from a very young age. Likewise, asked him the question, well, you've engaged in self-harm. So what's the difference between someone else strangling you versus you strangling yourself? That's probably not a big deal, right? I mean, which obviously no one, I mean, I can't imagine strangling myself, but I certainly would not want someone strangling me. So that's sort of just callousness and just sort of relentlessly going after our client and just making things difficult, fighting at every turn. And Sharif can probably, Sharif had to endure multiple leading up to trial, pre-trial motions. I mean, he may have set a record in the Commonwealth of Virginia in terms of the time spent in pre-trial motions leading up to this trial.
We had 2 hearings the week before. Zach, Nathan, and myself kind of split them, and I think the first hearing was 4 or 5 hours that Monday, and then the next hearing, the Friday before trial, was 8.5 hours or so, and it was painful.
Right.
And you didn't start till later, so it went to like 9, 10 o'clock at night.
Yeah, it was nuts. I mean, it was painful, but that said, I mean, on the whole, though, I mean, defense counsel were pleasant. I mean, did I think they made arguments that I certainly didn't agree with, and maybe did we think were unreasonable? Sure, but they were at least pleasant to interact with, and the judge also had a really good spirit about him too, positive and definitely concerned about making sure to get the right result. But without question, did the defense do everything in their power to try and limit our case or our ability to put on a case.
And you actually shared on LinkedIn that the Friday before trial, defense counsel read one of your LinkedIn posts to the judge on the record. And it ends with, every time I look at it, I remember, be myself, not some version of a trial lawyer, not what I think I'm supposed to sound like. Just me, curious, focused, sometimes funny, always real. Can you talk me through that moment where she brought up your LinkedIn post and how that played out in the courtroom and what you were thinking?
Yeah, happy to. And it certainly was surprising to me at the time. But the context of it was that the case had hit the news that week. And the video is, I mean, it's a graphic video. You're watching a caretaker drag a kid by the neck right across the dorm room, and that video was made very public, right? I mean, it got to the point where not only was it on the Winchester News in Virginia, but it hit DC News, it hit Fox News, right? And when we showed up for the hearing on Friday, I don't remember exactly at what point of the hearing, but defense counsel raised the publicity with the judge and argued for a motion to continue the case because they argued that the publicity would make it impossible to impanel a impartial jury. They also argued for a change of venue. And in making those arguments, they alleged that, I guess, our firm, and in particular that I contributed to this effort. Now, what was interesting about it, because I did make a post on LinkedIn that shared the article about, I forgot which organization it was, but I know at one point I shared the article, and I'm sure I said something like, "Our case next week, wish us luck," just something super small. And so when the defense attorney said, "No, Sharif, Mr. Gray has been online, like, sharing this," I'm like, "Well, yeah, I pushed share on the article and wrote, like, I don't know, like 2 lines. I can look it up, Judge, if you'd like." And then she goes, "No, no, 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 no. He wrote a lot more than that." So I'm like, "Huh?" And then she starts reading this post, and at first I'm dumbfounded, and then I'm like, "Oh my gosh, she's reading the My Cousin Vinny post." And so she's reading, and it's got like no mention. I think it may say Winchester, but it's like no mention of the party names,
Yes.
nothing. It's more or less, if you were reading it, unless like you were or living in Winchester and following the court docket, you wouldn't know it was about this case.
No,
And
it's about My Cousin Vinny, and you kind of referring back to yourself and your beliefs of what you should do and act like as a trial lawyer.
No, yeah, I mean, it's funny. And actually, Gray's accused me of posting that photo too much, so now it's a badge of honor for me. But no, every time we have trial, I tend to post that thing, which is a lot. It's become a lot of fun, and I think it is in some respects a good reminder for me and others, like that we're not supposed to show up as stiff versions of the lawyers we think we're supposed to be, but if we can show up prepared and be willing to be real and connect with the jury, chances are we're going to be in a better position to advocate for our client. And so one of the defense attorneys, and there's three, is reading the post, and she stops halfway, and unfortunately, I'm a little bit upset. I'm like, "No, no, 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 you're going to continue." And then
Yeah.
the judge goes, "Yeah, if you're going to read it, you're going to finish. Like, if you're going to put this into the record, you're going to read the whole thing." And so
Yes.
she keeps reading, and the second half of the post, right, is about the be yourself, all that
Yeah.
stuff, right? She's reading that, and then she gets to the end, and I'm like, "We're not done, Judge. There's a photo." Defense attorney, show the judge the photo, and she's like, "No, no, 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 no. I refuse to do that." I'm like, "Judge, it's a photo from My Cousin Vinny." And he goes, "Is it him in the red suit?" And I was like, "Yup." And then he started laughing, and then it was done. So
Yeah.
I mean, but it was really incredible. That was the first time that ever happened to me. I was, I guess, at times during that interaction, I mean, embarrassed, right? Like, "Oh wow, did I do something to potentially jeopardize this case?" I was angry, right? At certain times, I was like, "Why are they going after me?" Right? Like, I didn't do anything wrong. At least I didn't think. But then ultimately, like once we got through it, it's like that was stupid. I mean,
Yeah. I bet she
the
I bet she stopped reading halfway through because she realized what a mistake this was, because the post is so, you know, neutral and not even harmful or
But they had done their homework. I mean, they also during voir dire, I mean, they found an article that I wrote for our state bars magazine, the Virginia Lawyer, and they raised that article and introduced that into evidence and tried to imply that I wanted to ask certain questions and that I had an ulterior motive in wanting to ask these questions. And the reasoning was in this article that I'd published. So it was, I mean, again, pleasant, but they for I didn't and also I didn't believe that, frankly. I mean, up in that point, had I been involved in our team, gotten some great results? Absolutely. But I did not think that anyone would sit back and think, "Oh, I need to do research on this Sharif Gray person." But apparently
yeah.
they did.
Gray, you had mentioned that you hired a psychiatrist to evaluate, but you also, I don't think you guys had no expert witnesses at trial. How'd you guys come to that decision, and why?
I'd like to say that we had a lot of choices, but it was kind of, we were just limited. We ended up having, so the defense put on 14 witnesses, including two MDs, two psychiatrists. We put on four lay witnesses. So quite a disparity there. So we sort of struck out with having a psychiatrist who to evaluate and give an opinion on Charlie. And then also at a certain point in time, we did have a therapist who had seen Charlie, had been treating him at the time of this incident, before the incident, and also after the incident. And we thought she had some good information that was going to be helpful. Unfortunately, she lived 4 hours away from the venue and became very disinterested in cooperating and in going to trial, despite taking the oath to help Charlie. So we ultimately ended up having to, she was on our witness list and we had subpoenaed her. And so she was technically subpoenaed to be there in person for trial. But it became so hostile towards the end that we ultimately decided to jettison her because she was so bitter about having to travel 4 hours and be away from her kids and that sort of thing that she very easily could have just lied or could have just tried to torpedo our case. So we ultimately, in sort of having us being forced into that situation, we then focused on, okay, well, who are the witnesses who are really going to provide value and be able to speak to the jury and really be able to, give them the information and the credibility that we need. And so that first witness, the deputy, the law enforcement officer, she was a no-brainer, and having her come out first with that credibility was fantastic. We ultimately did decide, because the defense had kind of forced her hand on this, we ultimately did decide to put Charlie on the stand, and he did wonderfully. Amazing, resilient young man now. He's 16 years old now, I think. And we had Charlie's dad on there as well. And then we had a friend of the family who basically is kind of like a godfather or uncle to Charlie, and had known Charlie his entire life. And they were, the dad and the godfather, if you will, they were able to speak anecdotally about the effect that Charlie had, and like how he, following this incident where he was, attacked by a woman, how he had trust issues with women, how he became more aggressive, and all these things that happened immediately after this attack. And really able to drive home the lack of trust, and that was a big theme throughout the trial, from voir dire through the closing argument, is just this breach of trust by Grafton, generally, and more particularly by Michelle Yates, who was this caretaker who Charlie really looked up to and trusted, as was one of his sort of favorite caretakers. And ultimately, Charlie ultimately tried to protect her when she was, criminally investigated and prosecuted. Tried to sort of, after making the allegations, tried to back off of them. Maybe trying to make things easier for himself at the facility, and also sort of having the maturity to be able to see, like, okay, well, things that I say are going to have this effect on this person's livelihood. And so the defense maybe viewed that as a weakness of ours, but we turned it into a strength. It's like, here's this poor child who should be worried about, who's gone through all this unimaginable abuse. He should be worried about getting himself better. And instead, he's having to worry about this woman who attacked him and physically abused him. And he's now trying to protect her. Like, how messed up is that situation?
Right. And you mentioned the defense. They had some experts. Dr. Cheryl Willis was one of them. Can you talk about her testimony and how you guys handled that cross? Because I'm guessing if they're asking Charlie, like, well, were you normal before? And he wasn't. He was struggling, and he wasn't normal after. So what was her testimony, and how did you guys handle that cross-examination?
Yeah, so there are two experts, and Zach on our team did really just a masterful job on both. In terms of Dr. Willis, what Zach was able to do was able to build up getting her to agree as to what the standards are for a credible evaluation and opinion, right? And so asking questions to kind of set the standard that she just couldn't disagree with, right? And what Zach did that was, I thought was brilliant, was we have a whiteboard. Actually, it's in my office somewhere. It's over there. And put that whiteboard right next to her. And as he was going through it, was writing down, okay, it needs to be unbiased, needs to be complete, needs to be thorough, all that, getting her to agree with that stuff. And then also got her to agree that, well, if the expert took shortcuts or didn't do certain things, then it could be misleading, right? It would not be necessarily a credible thing for us to rely on. And once he was able to establish that, he was able to find some real just issues with the doctor's opinions. For example, one of the issues was, she wrote some 70, 80-page report, and half of it she spent blaming the father, right? Which, and of course, another issue was, the amount of money she charged was quite significant. But that really only carries so much weight if you can couple that with some more substantive issues. One that I think really stood out was the expert basically in her report, and then she doubled down at trial, said that somebody telling Charlie that he may have to testify at trial was traumatizing and was just absolutely unacceptable. And then Zach was able to juxtapose that with her opinion that this incident, albeit wrong, really was minor. And so you've got someone telling him something which the expert says that's horrendous, should have never happened, and then contrasting that with someone who literally strangles somebody, right? Like, and saying, no, that's minor. So
yeah,
I think once Zach was able to get through all of that, like, it really, it led to, I'd like to think it led to the jury not just putting too much weight in that expert's testimony. And we also, we got ahead of it, right? That's something that I think is really important with trial work. Is I don't think we had much of an opportunity to do it in voir dire because our voir dire was fairly limited by the judge, the defense. But in opening, we talk about things like, hey, one of your tools during this trial is you get to evaluate credibility. There's going to be a doctor who takes a stand, sits right here, raises the right hand, says they've been in school for 100 years, has all these degrees, da 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 da, right? And what we're going to do is we're going to ask you to look at them, to listen to everything they have to say, and to think to yourselves, and to go back into that jury room when this case is over, and to deliberate and say, you know what, was that person telling it like it is? Are they calling balls and strikes? Or are they pushing a little bit too hard for the side that hired them? And so we get it. We do that stuff at the beginning because we know what's coming down in the trial. And so I think the combination of that and really just the masterful job that Zach did on a varied, I'd argue probably the most difficult witness that we had from the defense. I think that was a significant factor in the success we had.
How did you guys kind of divide up it was a 4-day trial, I think. How did you divide up the courtroom? Gray, do you do the openings and Sharif the closings and Zach the crosses? Like, how do you guys kind of work as a unit?
Yeah, so I was really not too involved in the actual trying of the case. I was on the negotiations and also assisting, on strategy as well as with voir dire and stuff. But when we had that focus group, it became apparent to me that this was a case that was probably the best case that we had in the firm, and certainly in terms of ones that was coming up immediately within the next 6 months for trial. And so at the time, Sharif was not on the case. Zach was the main attorney on the case. We had just had, a couple weeks prior, we just had Nathan start with us. He was prosecutor in the city of Richmond. So he just started in November, on November 3rd of last year. So he's coming fresh from the Commonwealth Attorney's Office and joining us. And so really, I put the three of them on the case, with myself sort of helping out as well, but really them doing the lion's share. And Sharif is, very talented trial lawyer. And I think one area where he does particularly well is in voir dire and opening. And so thankfully I get to call the shots to a certain degree. So I was like, Sharif, you're doing voir dire and opening. And Zach had rebuttal. Nathan had the closing. Zach had been working on the case for a long time, so he was taking on these experts in terms of more some of the fact witnesses. Those are just sort of divvied up. But yeah, and so we have very capable attorneys in our office. Sharif, wonderful attorney. Zach and Nathan, fantastic attorneys. Nathan is very adept with sort of, PowerPoint, video clips, all that sort of stuff. So he came in from joining us from the Commonwealth from the prosecutor's office, and immediately he's going on the Grafton's website. He's downloading video clips of like things that they promised to do and all this sort of like. So in terms of framing, the whole team working together, you're able to put on just a very nice, polished opening, closing, and keep in mind, as Sharif described, there's these two pretrial hearings where one's 4 hours, one's 9 hours, and so all this stuff is changing. And so it's not like we were able to have something canned 2 weeks before trial and just sort of set it off to the side. There's a hearing that went till 9 p.m. on Friday. Trial started Monday morning, and it was Super Bowl Sunday, so it's like people forgot about watching the Super Bowl, and everyone had to go to Winchester. And of course, we have fantastic legal support, paralegal support. We have this wonderful paralegal, Laura Bradshaw, who's pretty awesome. And if you're on LinkedIn, you should follow her because she kind of gives some very direct and pointed posts from a paralegal's perspective on being working at a trial firm. So yeah, it was just very, very proud of like how our guys did and how they divvied everything up.
Sharif, I guess you handled the opening. What was that strategy? You mentioned that there was some bruises and scratches, but it's not like there was a lot of physical evidence. What was your approach to the opening, and how did you kind of frame it?
Yeah. So, and importantly, like the way that at least at our firm we view the opening is kind of as like the roadmap to the case. And so the opening is never just a one person project, right? I mean, I delivered it, but our whole team worked on it. And we were very intentional. We kind of have a little bit of a framework as to how we do our openings, but definitely very intentional about one, finding the universal value that everyone can connect with. And so in this case, it was trust. And so, for example, the first slide in the opening was actually an AI generated image of a father dropping off a child at who knows where it was, but let's just say a school or something. And I think the first words that I said were something along the lines of, every one of us here has been that man in that photo. Every one of us has dropped off a loved one, be it at a school, a nursing home, a hospital, you name it, right? We've done our research. We've talked to the right people. We've shaked their hands, and we dropped off our loved one, trusting that the people that we left them with would take care of them, and then move on to this case is about an institution that accepted that trust, about an institution that then violated that trust, and about an institution that, when asked to be held accountable, refuses. And I mean, I kind of paraphrased what I said, but that's very much the frame of the case that we started with an opening. And the point of that again was to connect this feeling, right? This level of trust and this loss of trust, this betrayal of trust with everyone. And then, of course, in the opening, we talked about who the defendant was. We introduced him to our client. We use a number of visuals. At our firm, we do the toolbox where we say, here are your tools, jury. And then we go into, I think we call like kind of the defense lies, right? And try and get ahead of things. And then we had the number. I mean, normally we try and do the number in voir dire, and we were not allowed to this trial. And so we did the number at the end of opening. And there we said, or I said without hesitation, that this case was worth every penny of $38.4 million. And the jury did not flinch. And we learned after the case that 5 of the 7 members of the jury were ready to give us $38.4 million. One wanted to give us nothing. And so they compromised somewhere in the middle at 20.
Was there a moment during the trial, maybe a piece of testimony or a cross-examination, where you felt the momentum shift? And maybe I'm kind of leading the witness here, but was it when you guys played the video? And what was it like showing the video? No, it wasn't the video?
No. Now, so what's interesting about that, it's a good question, is I mean, candidly, like, we didn't know how this case was going to turn out. And we had good results from the focus group. That's what made us think this case had value. We thought we did a good job, right? We hoped we did a good job, and we thought the number could be big. But at the same time, we weren't delusional. We also recognized the challenges of the case and that we could have gotten nothing for the client. And thank God our client trusted us to be willing to roll the dice. And to make it even harder, it's kind of what you mentioned in the intro, is that the defense actually lowered their offer during trial. So we're in two different worlds, right? So we've got our team, we think we're doing a great job. And then they've got their team of 3 lawyers, an assistant or 2. They've got an observer from the insurance company in the back, and they have the confidence to say, we're
Yeah.
going to lower our offer, right?
What
And
did you guys do there? Were you like, no, they're just playing mind games, they want to mess with
well,
us, or
one of the really nice things about how we've set up kind of the way we approach our cases is that Gray handles the negotiations.
okay.
And we actually did that for the first time back in the fall for a case. And it's such a great division of labor because for the trial lawyers working on the case, we don't even have to think about negotiations. Like, we just focus on the trial. There's no need to be like, oh, maybe I don't need to do that because the case is going to resolve. It's like it's not even something we think about. And so really, it wasn't something we thought about. It wasn't.
Gray, what was it like in that negotiation then when they were like, oh, you know what, we're not going to offer you 500, we think we got this slam dunk, we'll offer you 250?
Yeah, it's kind of like Sharif said. It was like we are operating. We're like two different solar systems.
Yes.
So, like you asked Sharif earlier, like was there a turning point? I thought we were off to the races from voir dire in the opening, and it was the defense had all these witnesses and they had 14 witnesses in total that they called, and I feel like they did their job and that they any possible defense, any possible roadblock they could put up, they did. But like they threw the kitchen sink at it, and I felt like at the end of each, and pretty much without exception, every witness that they put on, I felt ended up being more beneficial to us
Huh.
than to them. Usually it's like, okay, you put on, you have your opening and you put on your case, and it's like, if you don't feel good after you've had put your case on, it's like you're sunk. So of course we felt good at that. But then usually in most trials, in my experience, when the defense gets its turn, of course, and they're gonna score some points, and you're gonna get punched in the face a little bit. It just happens. I never felt like we were getting punched in the face.
So it's funny, and this comes to mind, but you asked is there a turning point. Bo Carell is a friend of our firm. He's a local lawyer up in Winchester, and Bo's a good guy. And he watched a lot of the trial, went out to dinner with us at least once, if not twice. And I remember at one point, I'm looking at my phone. It was Thursday night, February 12th at 6:04 p.m. I texted him, "This is going to be big." And he says, "Why do you say that?" And I said, "The defense is victim blaming." And so, if I remember correctly, that was most likely during the defense's closing argument. And so, of course, I wasn't confident it would be big, but it was,
Yeah.
I still had my doubts, right? None of us really knew, even up until the verdict was read. But that, I think, at least for me, I was like, they did everything that we could have wanted them to do, at least on the defense side.
What did it feel like when it went to the jury? Because they only deliberated for 3 hours, right? Were you guys feeling strong, but not quite sure what they'll come back with? Or I guess there's always a little voice in your head that might be saying, what if we lose this? How did it feel when it went to them?
Yeah, waiting for the verdict is not fun.
Yeah.
It's never fun at all. It's horrendous. I don't like. No human likes uncertainty, especially
Yeah.
your type A trial lawyer, right? Like we hate it, right? And I don't know. I think there was always that little voice in the back of the head. We're optimistic. I think we're proud. We put on a good case, but no. But again, we didn't know. We had no clue.
So where does the case stand now? Is Grafton going to appeal, or do they want to drag this on and get you guys back in the courtroom again? Or what's the next steps? Or do you think it's going to have some closure?
There won't be any appeals. It's the parties have resolved the case, confidential, of course, but that's really kind of all we can say about it. It was quite an experience.
Yeah. So I guess for attorneys watching who maybe have cases involving children or institutional care, group homes, maybe elderly abuse, treatment facilities, what does this verdict mean for them? And do you have any advice in terms of how to manage a case like this?
We, as injury lawyers, both on the plaintiff side, I think on the defense side, so often get sucked into this like framework of what we think a good case is. And I think if we're really going to do this work the right way and see the true value, we need to take a step back and, I mean, one, focus group our cases and see what regular people actually think, and two, kind of identify like, well, what is really the important thing here? What is the thing that has value? And I mean, Joe Freed is a friend and mentor of mine and our firm, and he is big on like, it's not about the diagnosis. It's about the feeling that's been lost, the feeling that's been taken. The example he uses is it's not about the broken foot. It's about the lady who no longer
Right.
gets that feeling when
Yeah,
she
the high
puts on
heel.
the high heels, right?
Yes.
And, or the guy who, that feeling when he revs the engine to his favorite car, he can't do that anymore. That's the value. And so the value in this case was, what is the full and fair value of taking away someone's hope, dignity, and trust? And that's ultimately, I think, what led to the significant number, because that stuff really does have value. Like, it really is. If we take a step back and actually think about it, that's the real important stuff. The lesson that I would want to share with others is, don't shy away from these cases. If it's a righteous case, dig, find what you need to find, and don't overcomplicate it. Come back to the universal value that we all hold so high.
Yeah, and I would just add, I think you also asked about, people who, they or their loved ones have been subject to abuse. Think about Charlie's dad in this instance. So he went to multiple law firms before he came to us and was turned down, and he didn't quit until he found someone who would be a champion for his son. And a lot can be said about work, attorneys working on contingency fees and things like that, and lawyers making a lot of money when they get big results. But I mean, it's because of that contingency fee that we're able to take on cases like Charlie's, where the family doesn't have the means to hire an attorney and pay them on an hourly basis, especially for like 2.5 years, and what it takes to go forward on a case like this. And so it's something that our firm has embraced in terms of taking on these cases where they're a little bit outside the stereotypical personal injury case. They're not your normal motor vehicle collision or standard slip and fall. They're cases, especially ones where there's corporate wrongdoing and there's someone where there's really been a violation of trust, and just where someone's dignity was taken away, like it was in this instance.
Well, there you heard it. A 13-year-old boy entrusted to a psychiatric facility to heal from trauma, abused by the people who were paid to protect him, evidence destroyed, and 2 military veterans who wouldn't back down, or maybe 3, right? $60,000 offered, $20 million awarded. Gray and Sharif, thank you for joining us and contributing to the Trial Lawyers Journal. This was Behind the Verdict. See you guys next time.